7. The state and the child. The state has a sovereign power by means of its legislative acts and the authority vested in its governmental divisions to protect the child whose parents, because of their mistakes and failures, neglect to do so. The state also assigns certain responsibilities for all children, laws to safeguard health. A child is not aware that the moment he comes into the world, the laws which control his whole life are in operation. For instance, the law provides that a physician or other qualified person, licensed under the statutes of the state, must officiate at his birth. The birth must be recorded that the child may be on record as a legal personality. Pure food laws and properly tested milk give him adequate protection from infection. And health laws make vaccination necessary before he may enter school. Here again, through periodic examinations and health instruction given by doctors, dentists, and nurses, the child continues on the road toward health. Mental as well as physical health is considered, and in many states the Department of Education provides clinics where mental abilities can be ascertained and emotional problems adjusted. School laws. The statutes prescribe the age at which a child shall enter school and how long he must continue there before he can go to work. In many states it is compulsory to attend grade school until 16. But there are exceptions to this rule. In most states, a child can leave at 14 if he has finished a specific grade, if it is necessary for him to work in order to help maintain the family, or if he is physically or mentally handicapped so that he is incapable of learning. Laws to regulate employment. The laws regulating employment have gone hand in hand with those prescribing compulsory education, and there is a long history back of this which is pretty dark in spots. The Puritans and the Quakers felt that idleness was a sin, and this attitude led to an exploitation of children in industry during the early years of this country's development. New England led with a record of children 10 years of age and even younger working in the cotton mills for 14 hours at a time. This was to teach them a useful trade and make them capable of supporting themselves. In 1836, Massachusetts passed a law making compulsory school attendance necessary for at least 3 months of the year. Other states followed with provisions regulating the age of employment. But it was not until about 50 years ago that birth certificates were required as proof of age. There were many parents who falsified the age of their children, and altogether state legislation failed to cure the evils of child labor. The first federal child labor law was enacted in 1916 and set the minimum age for employment at 14. This law was based on the power of Congress to regulate interstate commerce and was declared unconstitutional by the United States Supreme Court in 1918 in the well-known Hammer v. Dagenhart decision. The Supreme Court declared, commerce consists of intercourse and traffic and includes the transportation of persons and property, as well as the purchase, sale, and exchange of commodities. The making of goods and the mining of coal are not commerce, nor does the fact that these things are to be afterwards shipped or used in interstate commerce make their production a part thereof. Over interstate transportation or its incidents, the regulatory power of Congress is ample, but the production of articles intended for interstate commerce is a matter of local regulation. This placed the responsibility back on the states, a practice which is so widely advocated today along other lines. The second federal child labor law was passed in 1919. This was based on the taxing power of Congress and levied a tax of 10% on the profits if children were employed in violation of the age and hour standards of the bill. It likewise was held unconstitutional in 1922, and the Supreme Court again declared that under the Constitution this was a matter to be regulated by the states. Since that time there have been other attempts to control child labor. In 1924 there was a proposed amendment to the Constitution which, as with all amendments, required a ratification by 3/4 of the states in order to become a law. As this was ratified by only, it never went into effect. In 1933, 28 states, under the National Recovery Act, an attempt was made to meet the unemployment situation by prohibiting, with a few exceptions, the employment of children under 16. This was declared unconstitutional in Schechter, Poultry Corporation v. United States. In 1938, further federal legislation was introduced, and Congress passed the Fair Labor Standards Act, or the Wages and Hours Act, which became operative in October 1938. This prohibits the shipment and interstate commerce of goods made in establishments that have employed child labor within 30 days prior to shipment. Oppressive child labor means the employment of children under 16 by anyone other than their parents, or the employment of children under 18 in occupations which the chief of the Children's Bureau shall declare hazardous, or detrimental to their health or well-being. Children employed in agriculture or as actors in motion pictures or theatrical productions are not affected, and a large group of children who are employed in interstate industry and mercantile establishments, as well as many others, are not included. It is almost impossible to obtain accurate figures on child labor, but the 1930 census showed that there were more than 600,000 children from 10 to 15 years of age that were gainfully employed. This was considered an underestimate of the total number because the census did not include children under 10. 70% of these children were employed in agriculture or as unpaid family workers. Many of these will still remain unaffected by the Federal Wages and Hours Act, but child labor in industrial plants which ship goods and interstate commerce will be ended. This act brings about a cooperative plan of control which was not possible under the separate state laws. It is administered by the Federal Children's Bureau in cooperation with state and local offices, provides for investigation and inspection of employment, and penalizes any employer who violates the provisions of the act. A special court for children. Laws for the protection of animals antedated laws to protect children, and in 1875, when a little girl was cruelly beaten in New York, she had to be considered as a little animal in order to receive legal protection. This resulted in the establishment of agencies all over the country for the prevention of cruelty to children. In time, the essential rights and protection of children became so important that a special court, called the Juvenile Court, was established. The first one was in Cook County, Illinois, in 1899, and this was quickly followed by similar courts in New York, Indiana, New Jersey, and other states, until at the present time all states make provision for hearings on juvenile cases. The Juvenile Court was started as an experiment in legal procedure and has continued on that basis. For its precedent, it had the Court of Equity and, like it, was founded on the desire to break away from a harsh and rigid procedure, which in this instance was the application of criminal justice to children. This court was therefore based on the concept of equity, that is, a consideration of the welfare of the child instead of punishment for the offense. It looked upon the offender as an individual and his acts as symptoms which needed to be understood. In other words, the legal system which prescribed rigid punishment acted in a new light if the offender was a child. We should not lose sight of the fact, however, that though this court takes a social viewpoint in the exercise of its duty, it is nevertheless a court and its function is primarily a judicial one. It has the power to exercise this function only within the limitation and jurisdiction prescribed by the statute, notwithstanding the fact that its procedure may be less formal and its rules of evidence less rigid than other courts. The jurisdiction of the Juvenile Court includes neglected, dependent, and delinquent children. The 1929 White House Conference Committee on Juvenile Delinquency defined the acts which came under the early jurisdiction as any such juvenile misconduct that might be dealt with under the law. A delinquent child is often defined as any child who violates any law of the state or who is incorrigible, knowingly associates with vicious and immoral persons, or is growing up in idleness and crime. A dependent child is one who is without support or who begs or receives alms. The term neglect is broad and includes physical, moral, and usually medical neglect. The juvenile court may be a separate court or a division or session of another court, and sometimes in serving rural areas it is on a county basis. Jurisdiction of the juvenile court. The jurisdiction of some juvenile courts has been extended to include cases of adoptions, of mental defectives, and of illegitimate children. There is some variation in the age when jurisdiction can be acquired, though in about half the states these courts can take jurisdiction of a child at any time before the 18th birthday, and when custody is once given by order of the court it generally continues through minority. It is a well-accepted concept that the juvenile court jurisdiction should be exclusive up to the age of 18. But in many states, children who have committed a serious offense are bound over to the higher court, and the old criminal procedure is applied. Hearings are then no longer private, and instead of considering the child according to juvenile court standards, he is looked upon as a criminal. Objectives. The person who is sitting in this court, whether judge or referee, should be especially qualified for the work. He should have not only legal training but also a social consciousness and a knowledge of the aids which science has developed toward an understanding of children. Therefore, the investigation of a social worker should be a requirement, for this will bring the court a knowledge of the family background, environmental factors, school history, and the child's relationship to his family and the community. There should be a medical examination. And, finally, the searching inquiry of a qualified psychologist and psychiatrist for a better understanding of the child and the problem. When this is required, the judge will be in possession of all the facts that intelligence and science can bring to the problem and is less apt to make an unwise decision. For instance, a child of very low intelligence will probably not be sent to a correctional institution when training in a school for the feeble-minded will provide more adequate care, pending disposition. In many states, the law provides that a child cannot be held in jail pending the hearing. In large cities, children are held in detention homes or in private foster homes when it is necessary to take them into custody at once. For example, if they are runaways and their appearance in court cannot be relied upon, or their delinquency is very serious and their release will endanger the public, or they must be held as important witnesses. Probation officers. With the properly equipped juvenile court, the law provides for one or more persons to act as probation officers. These officers sometimes assist in the investigation, and, if a child remains in his own home, act as friends to counsel and advise both the child and his parents. This can be effective or not, according to the personality of the probation officer, who is a very important part of the court system. There have been a good many cases attacking the constitutionality of the juvenile court law, either on the ground that the parent's legal rights as custodian are violated, unless he is made a party to the proceedings, or that the right of a jury trial is denied. A case in Illinois a few years after the passage of the act shows the early attitude toward this particular legislation. In this instance, a writ of habeas corpus was brought by one Joseph Schwartz against the superintendent of the St. Charles Home for Boys for unlawfully restraining his son, Samuel Schwartz, 14 years of age. It was shown that the father lived in Chicago with his family, consisting of his wife and 2 children, that he provided a good home for them, and that he supplied them with the necessities of life. The son, Samuel, was charged with repeated indecent assaults upon 2 girls in violation of the criminal code of the state, and he was committed to the St. Charles Home for Boys until 21 years of age. The parents were ordered to bring the boy to court, but they were not made parties to the proceeding or charged with the omission of any parental duty. The court agreed that the commitment was according to the provision of the act to regulate the treatment and control of dependent, neglected, and delinquent children enforced July 1899. For Samuel was a delinquent boy within the meaning of the act, but that it was not within the power of the state to seize any child under the age of 16 who had committed a misdemeanor punishable under the criminal code of the state by fine, and take him from his home and the custody of his father, as it was an infringement upon parental rights. Though the court admitted that an extraordinary exigency could justify the state in supplanting the father as the natural custodian and protector of his son, it did not exist in this case. Further opinion stated by the court was to the effect that it did not hold the statute regulating the disposition to be made of delinquent children to be unconstitutional in toto as to every parent and to all children, but in this case, constitutional rights of the father had been infringed and the detention of Samuel could not be upheld. The law was amended in 1907, and later cases in Illinois sustained the constitutionality of the Juvenile Court Act. Between 1899 and 1909, the validity of such laws was passed upon in Florida, Idaho, Pennsylvania, and Utah, and was sustained by the Supreme Courts in those states. Mother's Aid legislation. Great social progress, backed by legal provision, has brought about protection for another group of children. When dependent children first became a matter of public concern, they were apprenticed, and a little later cared for in orphanages. More recently, the plan of placement in foster homes has developed, and along with it the system of Mother's Aid or Mother's Pension, which gives aid to mothers so that children can be cared for in their own homes. This took the place of some form of poor relief and is included in the security legislation under the provision of aid to dependent children, which will be taken up in more detail later. The constitutionality of this legislation has been attacked on the ground that these laws make an arbitrary selection of beneficiaries, or that public funds are not applied for public use. One of the early decisions on the first point was in Washington in 1916. Rose Snyder had received an allowance under the Mother's Pension Act in October of 1913 because she had been deserted by her husband. A later act in 1915 provided for allowances to indigent mothers whose husbands were dead or incarcerated in a penal institution or insane hospital, or whose husbands were unable because of total disability to support them. Mothers who had been deserted were not included. The court held that the first law did not provide for all classes of indigent mothers, and that the second one was not unconstitutional as class legislation on the grounds of arbitrary selection. It further held that the state had a right to provide for the care of its indigent in any way it wished, and at the discretion of the legislature. The responsibility of the county commissioners was decided in a case in Utah. In 1922, there was a law authorizing the county commissioners to provide funds annually for the support of widowed mothers. It was held that this law was mandatory and put a duty upon them which was not fulfilled when they provided for widowed mothers out of a fund to provide for indigent and dependent poor, including widowed mothers. The question of divorce and custody also was involved in one Mother's Aid case. This concerned the children of Charles and Gunn Koopman, who were divorced. The father had deserted his family and was a fugitive from justice, and the mother had been given the custody of the children at the time of the divorce. The mother had a right to relief unless barred by divorce. The Supreme Court decided that the purpose of the statute was to provide for the welfare of dependent children whose parents could not care for them, and the Mother's Pension Act was held to apply to a mother with dependent children although she had been divorced. Other groups of handicapped children. The state gives protection to other groups of handicapped children in a different way. There are more than 10 million physically and mentally handicapped children in the United States. The individual states have a responsibility toward them to see that their latent abilities are developed, and that they become assets to the community and state instead of liabilities. This group includes those who are deaf or hard of hearing, blind or have partial sight, crippled children, or those suffering from tuberculosis or serious cardiac disturbances, as well as the group included under the generic term of mentally deficient. This last group is composed of those who are feeble-minded, such as the idiots and imbeciles who can never be socially or economically adequate, many morons and borderline individuals who are also inadequate, and many other morons who with training and supervision may become efficient enough to manage their affairs and meet the stress and strain of life. All these groups present problems of adjustment, and in working with the many complications involved, the social worker is prone to forget that legal provision accompanies social planning and is an important part of any program. Legal provision. Legislative acts have established various state departments and have made provisions for the care of the blind, deaf and dumb, crippled, and the feeble-minded, either in institutions or foster homes, according to the needs of the child. The care and education should be broad if the physical and mental powers are to be developed to their fullest capacity, and this involves a knowledge of the needs. It is possible to obtain this knowledge through studies authorized by the legislature and undertaken by various departments of health, education, and welfare working toward a coordinated legislative program. 3 processes are involved. First, the handicapped child must be discovered and reported to a central agency. Secondly, he must have medical care and necessary appliances. And lastly, he must have education, which includes guidance to assure proper selection and training, and placement with supervision. This is the ideal program and is not provided for every handicapped child. But the goal seems near since the federal government has become interested in the welfare of its children and through the Social Security Act is assuming some of the burdens formerly carried by the states. Legislation relating to the feeble-minded and the insane. There has been a good deal of legislation pertaining to the care, education, commitment, and even sterilization of the feeble-minded, but the early laws made no distinction between the insane and the feeble-minded. As a class, they were all considered persons non-composed mentis and included under the term insane, which was the legal term covering mental unsoundness of any sort. When insanity was set up as a defense in a criminal case, the legal test, according to a rule laid down in McNaughton's case in England nearly 100 years ago, was the so-called test of right and wrong. That rule is, if an offender has sufficient mental capacity to know that the act which he is about to commit is wrong and deserves punishment, and to apply that knowledge at the time when the act is committed, he is not in the eyes of the criminal law insane but is responsible. This test is followed in many jurisdictions today. It seems quite clear that legal concepts have not kept pace with knowledge in the fields of medicine and of psychiatry. Even lay persons today realize that there is a vast difference between the insane and the feeble-minded, and that it is sometimes as necessary to provide protection from those individuals as to provide care for them. This is especially true of the defective delinquent, who is often implicated in sex crimes of the most revolting sort. The decision, which involves punishment or care, should not be based on a fine legal point, but should be determined from consideration of the mental and emotional adjustment of the individual. Every state should have a law similar to the one in Massachusetts, which provides that any person who is to be tried for a felony must have an examination by a psychiatrist. After the examination, the court should be guided by this opinion in determining the release or restraint of the individual. If this takes power from the court, it also divides the responsibility and would assure a smaller number of dangerous persons at large. Education and training of the feeble-minded. In institutions, during childhood, the education of the feeble-minded can often be more satisfactorily supplied in an institution where the child has to compete only with those of like intelligence and can be taught to do many tasks which give him happiness and at the same time make some contribution to society. These institutions are a responsibility of the state and generally either accept children directly on application from parents, public officials, or other sources, or require or permit commitment in the same manner as for the insane. Others provide for commitment through some judicial tribunal, which necessitates a petition setting forth the facts. This is followed by a hearing with the testimony of either physicians or psychologists, who can give the court the benefit of their knowledge as specialists. In the community, the time has passed when specialists feel that every mentally defective child should be in an institution. With the exception of the helpless, low-grade cases, many such children can be trained to compete with their fellow men and pursue their affairs in the world with ordinary prudence. The Department of Education in many states has assumed a responsibility towards these children and provides special classes and education in hand and manual training rather than in academic work. Registration with this board is important and is required in some states so there can be information concerning the number of children and the place of residence. Sterilization of the feeble-minded. Marriage of the feeble-minded is prohibited in some states, and sterilization, which is a much more effective method of preventing parenthood, is permitted in 31. The first eugenic sterilization bill was introduced in Michigan in 1897. Pennsylvania passed a law which was vetoed, and Indiana adopted a law in 1907 which was later declared unconstitutional. So Washington and California, both in 1909, were the first states which passed effective laws. And California probably has a record of more such operations than any other state in the country. The United States Supreme Court sustained the legality of eugenic sterilization in a case which came upon appeal from Virginia. Carrie Buck, an 18-year-old feeble-minded girl, the child of a feeble-minded woman and the mother of a feeble-minded child, was in an institution and sterilized against her will. Justice Holmes, in handing down the decision, said, "It is better for all the world if instead of waiting to execute degenerate offspring for crime or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. 3 generations of imbeciles are enough." There is a great deal of misinformation about this particular subject, both as to the social implications and the legal safeguards. In the states which permit sterilization, there is often a fear that anyone who goes to a state institution will undergo this operation. But as a matter of fact, many defectives in state institutions are not proper subjects for sterilization. Helpless epileptics and idiots, though included under the terms of the law, as a practical matter need custodial care for life, and therefore should not be considered for sterilization. One state which has a very comprehensive state law limits the operation to anyone who by the laws of heredity is the probable potential parent of socially inadequate offspring likewise affected. It further safeguards the individual by providing for the consent of the guardian, and for a hearing which shall be a matter of record, with the right of appeal and preservation of all constitutional rights. The hearing must be conducted before a board and detailed proof of heredity is necessary. If this cannot be produced because relatives are dead or are foreign-born and inaccessible, the operation is not possible. Legal and social responsibility of the state. In any consideration of the responsibility of the state toward its children, it should be quite clear that the relationship combines the social and legal aspects, and at times there is such a coalescence of the two that they seem synonymous inasmuch as both fields of endeavor involve the rules of living as they apply to the individual. The New Hampshire law contains these provisions.